Hey, all persons due before the Honorable Justice of the Appeals Court, now sitting in Boston, Commonwealth of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, this court is now open. Please be seated. Moderate.
Good morning. Welcome to the Appeals Court. I'm Justice Mead. With me today are Justice Shin and Tam. They will be the panel for all of the cases. Each side gets 15 minutes. You needn't use all of your time. We don't entertain rebuttal. And we have read everything, so my best advice is to get right to the point. With that, our first case is 24P1015 in the matter of James Lavers. It's partially impounded.
Good morning. May it please the court. Attorney Deborah Dow for James Lavers. Mr. Lavers is listening in today on the YouTube live stream. This is a case about fundamental fairness. This was an initial guardianship petition sought for a United States veteran of the Vietnam War who served this country from 1969 to 1972. Up until he was admitted to the VA hospital in October of 2022, he had lived on his own in the community, and he had been fully making his own decisions. No one was substituting judgment for him. The request by the VA to appoint a guardian with no limitations meant that one day he had full decision-making ability, and the next day he had none. A guardianship is a substantial deprivation of the respondent's liberty interest and entitled him to due process. Due process, as we know, is the cornerstone of a fair legal system and ensures litigants are treated with dignity and respect and provided with notice and an opportunity to be heard in a meaningful time in a meaningful manner. But Mr. Lavers didn't get that. It's undisputed that Mr. Lavers' trial counsel did not file a witness list. It's also undisputed
Why
that
was
petitioners...
that?
I'm sorry, Your Honor?
Why did they not file a witness list?
All trial counsel said was that she forgot, is the gist of that.
So, counsel, you argue that it's error that the judge did not allow your client to testify at the hearing. But what you didn't mention in your brief is that he had the opportunity to actually speak, essentially give a narrative, which one might argue, right, was actually an opportunity to be heard in a broader sense than if he were allowed to testify as a witness, right? He was able to speak and say he didn't believe he needed a guardian, thought he was capable of taking care of himself, which is in transcript 122, right? And he wasn't actually subjected to any cross-examination or any limitations that I saw from the record in what he was able to say.
So he was permitted to do a narrative, and during that narrative, he expressed again that he did not want a guardian and felt that he did not need a guardian. And then what happened was that the judge proceeded to ask him questions for which counsel could not cross-examine. And so at that point, Mr. Lavers, again, was denied due process.
Was there an objection to this?
An objection to? She did object to the fact that she could not call him as a witness.
But then, as Justice Tam just said, but he basically testified and answered questions by the judge. Was there any objection to that process?
No, there was not subsequently, but there was an objection to the fact that he couldn't testify. And that testimony would have included the ability to have counsel assist for counsel to cross-examine, and that opportunity was not even offered.
So,
sorry, Your Honor.
what was left out? How was he prejudiced? What would he have said had he been permitted to testify that he didn't say in his statement?
So well, first of all, I would suggest to the court that an offer of proof under the Lech versus Daniels case, which I did submit as a 16L letter, is not required where the judge has wholly excluded testimony on an issue, which is what happened here. But that said, I think that there were...
I'm sorry. How do you say wholly excluded, but he made a statement?
Again, without the aid of counsel, without any type of
Okay, so let's get back to my question.
To direct, I'm sorry.
What was he not able to present to the judge in his statement that he would have been able to present if he'd been permitted to testify in a more conventional means?
Well, I think that there were quite a few things, including the fact that what providers he actually had in the community, what type of natural supports he had in the community, what technology did he know how to use and could use, which is a requirement under the decree under 5306. What technology had been actually offered to him. I think it would have given the judge the ability to assess him as far as both credibility, understanding, his ability to communicate, his ability to observe, to remember.
Wasn't that explored a little bit on during his narrative? He was asked some questions about some of the events that took place that I think were critical in the judge's, I think, decision, right? And your client wasn't able to remember or had a different memory than the witnesses who had testified before.
Well, again, that was certainly without the aid of counsel or being able to cross-examine or to get additional information out of him. But he, and I think it sounds like Your Honor is referring to the question of whether or not he took medications. And there was certainly testimony that he said that he had not been prescribed medications. It was unclear what he was referring to because in the end, he says, this is on page 129 of the transcript, the only medications taken are are where they have me now. Essentially, he said, they give me meds now in the hospital. So he seemed to be able to clarify that or differentiate that, but unfortunately, again, because he was not able to be questioned and have that information fully explored, it sounded as if he was not taking medications, when in fact, I think at the end, he did clarify that. So I don't think, what I'm saying is that there can't just be a full stop. Respondent was not, who's a party, was listed on petitioner's witness list, but unfortunately, trial counsel for respondent didn't file a witness list. It can't just be dispositive. We can't just stop at that analysis. There's a due process violation. And frankly, there's a massive curtailment of liberty in this case where you have a person who was under their own judgment and now is not. And I think the case law is supportive of that. And while the petitioner seems to argue that there should be a full stop and that it's not, the pretrial scheduling order wasn't followed, but there's more to the pretrial scheduling order, which seems to also have not been followed. And that includes an analysis of good cause. So should that witness who's a party have been excluded from testifying solely because of the pretrial scheduling order, there can't just be an analysis of it's not on the pretrial, she didn't follow the pretrial scheduling order because she didn't provide a witness list.
And she didn't have good cause, right?
I don't think there was analysis of good cause, Your Honor, with all due respect. There has to be something further. Was there prejudice? Would there have been prejudice? Would there have been time to cure the prejudice, if there was any? And counsel doesn't articulate that. In fact, there's no possible way he can articulate that. All he says is, it's not on the scheduling order. She didn't follow the scheduling order. We're done.
But you say there wasn't any question of good cause, but there was an examination of why she didn't file it.
Which she had no explanation for, Your Honor.
Well, that's not good cause.
It doesn't seem as if it's good cause pursuant to the case law. And while there's nothing that I could find necessarily on point to a guardianship, there's certainly case law in respect to the criminal context as well as civil context, not just in our jurisdiction, but in other jurisdictions. And that's the analysis that it goes through. Is there prejudice? Were there less severe sanctions than just excluding that witness? And I would suggest the answers to all those, to that question, is absolutely yes. Was there prejudice? There's nothing been articulated to show that there's prejudice, not when petitioner himself had listed the respondent, the party, on his own witness list. The problem is, in the end, that the judge did not have the full panoply of information from which to render any type of decision or statutory findings under 5306. Ascertainment of facts from just one side certainly doesn't lend itself to a full and fair hearing as far as a substantial liberty interest, as in this case, the deprivation of someone's ability to make decisions for themselves. This was a grossly disproportionate sanction. And I would suggest to the court that there were lesser sanctions and there was no prejudice for allowing Mr. Lavers to testify. And if there are no further questions, then I would rest on my brief.
Seeing none, thank you. Mr. Bolio.
Good morning. If it pleases the court, Attorney Matthew Bollier representing the appellee, VA Boston Healthcare System. I'm going to be quite candid with you. I did the trial in this matter as well as doing the appeals, and I was quite shocked when the trial court upheld my request that Mr. Lavers be not allowed to testify. I expected him to overrule my objection and allow Mr. Lavers to testify. And it was for that reason that I proposed that Mr. Lavers be allowed to make a statement.
Why did you object?
Because, Judge, I think witness lists should mean something. There are many guardianship cases tried. My own office tries something on the order of 1,500. Well, we don't go to trial on most of them, but we file over 1,500 guardianship cases a year. Major neurocognitive disorder, which is one of the conditions this patient suffers from, is really a horrible condition. And one of the hallmarks of that condition is that the victim of it oftentimes is the last person to recognize that they're suffering from it. That's a common human experience. We've all seen elders who begin to slip, a little memory slip here, forgetfulness, leaves the stove on, inability to take care of themselves, can no longer do toileting, and so forth and so on. And while, as my sister points out, Mr. Lavers was perfectly capable of managing all of these things for the vast majority of his life, he hit a point where he couldn't any longer. And that's when the VA intervened and filed a petition for guardianship. Now, most of these cases, judges do not go to trial because most of the time there's overwhelming evidence. And much of the time the respondents eventually acknowledge that they could benefit from having some help, some assistance, a guardian there to close the loop, if you were, to get them the special attention or the special services that they need. But there's a percentage that say, no, I can do everything on my own. And Mr. Lavers certainly fell into this category, as evidenced by the fact that in his statement at the trial, he said very clearly he felt he didn't need a guardian. He felt he could do everything on his own. Now, we had a pretrial. We had a pretrial order indicating when the trial lists, the list of exhibits, the list of witnesses were supposed to be submitted. We did all that. Petitioners did all that. We submit our list. We don't know what's going to be on the respondent, on Mr. Lavers' list at the time we're submitting it. So we sometimes include things that may not be necessary, but may be appropriate based upon what we see on the respondent or Mr. Lavers' witness list. When we don't see a witness list and we don't see an exhibit list, and we note that there's been a motion, as you can see in the docket, a motion for fees for an independent medical evaluation, and that independent medical evaluator is not testifying and is not offering any affidavits or opinion evidence, it suggests to us that the respondent, in this case Mr. Lavers, does not really have a compelling argument to overcome the bulk of information that we have. But to give dignity and respect to each respondent, we go to trial anyway, and we have to present this information. And we have to present counsel with an opportunity to cross-examine our own doctors, all of which happen. We don't prepare in those cases oftentimes to cross-examine Mr. Lavers, people in Mr. Lavers' position. It's difficult for them. It's difficult to ask someone, why don't you remember this? You know, don't you remember when you fell? As evident in the way the judge was asking questions. Judge, very delicately, I don't mean to embarrass you, Mr. Lavers. I don't mean to upset you, Mr. Lavers. So if we don't have to call Mr. Lavers the respondent in these cases, we don't. And that was our expectation. Now, had Mr. Lavers been on the witness list, I may have had another witness testify on my case, another social worker perhaps, to be able to elaborate a little bit more on what went on in Mr. Lavers' home. So there was some prejudice. All of that said, I want Mr. Lavers to have his day in court. And that's why I asked the judge to allow him to speak, to allow him to say his piece. I said to the judge, ask questions, Judge, because the judge has an independent duty to do an assessment of this man's capacity. Sometimes that takes a long time. Sometimes it doesn't take very long. But one thing that's essential in doing that assessment is the eyes on the
Why
witness.
would it have been so different to allow him to testify?
Judge, I think in this case that the testimony would have been a bunch of leading questions leading him down this line of argument that wasn't going to be productive and would have been embarrassing and would have been difficult for him. I think it would have been, Mr. Lavers, you know how to cook, don't you? Mr. Lavers, you know how to buy clothes, don't you? Mr. Lavers, you don't need anybody to wipe your bottom, do you?
But he wanted to testify, though, right? In terms of what you just said about giving him his day in court.
Well, but he didn't, because he said his statement, and the judge said, is there anything else you want to tell me? And he said no. He just wanted to make his statement. I don't even think he wanted to answer the judge's questions, honestly. I think he was done. So I don't know how long this examination was going to be, but it wasn't going to be a benefit to Mr. Lavers, I don't believe. Certainly the questions that he did answer for the judge were more benefit to the petitioner than the respondent. I think the judge saw very clearly, very quickly, honestly, after Mr. Lavers started speaking, and in the context of having just heard from the doctor and the social worker, that this was a man that needed assistance. The judge notably took 90 days to reach a decision. I think the judge was very deliberative in his assessment of this. It's very unusual that we don't get a decision within a relatively short period of time. So I don't believe that there was any prejudice. There's certainly been no showing of any prejudice. I note that there was no request to continue the trial, to have an extension. There was no suggestion of ineffective assistance of counsel. There was no affidavit saying, well, Mr. Lavers would have told the judge all of this information that would have made a difference. There was none of that. And there, quite frankly, should have been, if there was any prejudice to Mr. Lavers not being cross-examined or directly examined by his trial attorney. I think that the trial attorney didn't, I'm not going to put my own analysis on what his trial attorney thought, but not having a witness list, not having an exhibit list, there should be a consequence to that. And while absolutely not letting Mr. Lavers speak at all is probably too far, as my sister says, Mr. Lavers was given the opportunity to say whatever he wanted, in any way he wanted. And he was given the opportunity to answer questions from the judge. And the judge had apparently heard enough to satisfy his needs in the context of the broader spectrum of the testimony that was offered that day. So I don't believe that there's a huge due process violation here. I certainly don't believe that there's any prejudice toward Mr. Lavers. I would also point out to the court that Mr. Lavers is free at any time to file a petition to terminate the guardianship. While we call them permanent, they're never really permanent. If his condition changes or improves, he can do that. Similarly, if he believes that there are some limitations that are appropriate to the guardianship, which weren't included, and I think there were, but I don't recall off the top of my head, he can always petition to modify or limit the guardianship. If he wants counsel, he can request that counsel be appointed. There's an ombudsman in most facilities that will arrange to contact CPCS and arrange for counsel to assist him with all of these things. So I believe that the trial judge acted appropriately given the circumstances. I believe that there's no prejudice to Mr. Laveris, and I believe that the decision should be upheld. The other arguments raised by my sister in her brief regarding the medical certificate, I think it's sort of a misunderstanding of the fact that a medical certificate is a pleading and not evidence. The medical records part, again, the medical records had to be offered so that the doctor could testify as to the reasons why he was forming the opinions that he did, which were, asked in cross-examination of the doctor anyway, so they would have come out anyway. So there's no prejudice in there, and I believe that the medical records were properly submitted and available to the respondent's counsel for almost an entire year. So I would ask that you affirm the trial court. And if there are no other questions, I'll yield the rest of my time.
Seeing none, thank you. Thank you both. We'll take it under advisement.
Thank you.
Our next case is 24P 1074, Dennis versus Correa. Mr. McMahon.
Good morning, Your Honor. Attorney James McMahon for the petitioner and the appellant, Nancy Dennis. Your Honor, first I want to thank you very much for allowing me to be here to present this matter before you. It is indeed an honor and a privilege. Nancy Dennis, 71-year-old lady, resident of Wareham, been a resident of the Commonwealth most of her life. She's held a firearms license for almost 40 years.
Can I ask a housekeeping matter? You say in your statement of the case that you're appealing not just the denial of the renewal application, but the suspension as well.
Yes.
But your notice of appeal doesn't mention the suspension, and the suspension occurred in 2022, so it's
yes.
too late.
What had happened was we had amended the petition timely when we filed the original petition. It was because of the suspension. During that time, her suspended license expired. So we filed another application. And with that other application, we filed everything with it. We supplemented it. It was a pretty thick application. And we submitted that and amended the petition so that the petition is not only for the suspension, the original suspension, but also for the denial of her.
Your notice of appeal does not mention the suspension.
Well, it...
Rule 3 requires you to mention all the orders you're appealing.
It should, but it was all one and the same order. So it was the order that was issued in the district court because they were heard together. It was joint. And there was one decision from the district court that went to the Superior Court, and that's where... So it's all one in the same package.
Go ahead.
Okay, so the incident date, and that's what we're talking about, is the incident date, was November 12, 2022. And the incident was an argument between her and her domestic partner. I know the police report calls it wife, but they were in a domestic relationship, but they weren't married. The Wareham Police Incident Report has a number. It's 22-635-AR. It's a one-page document, two paragraphs, essentially. And it is the Officer Ring, putting down in the first paragraph a statement that Nancy Dennis's domestic partner Richard Goucher reported to the officer in the driveway. The officer says that Nancy was arrested based on the statement by Richard Goucher. There is no evidence. There is no, other than that statement. There is, the officer didn't do any further investigation, didn't find the so-called rag or the oil-dipped rag. He
So how
makes
do you-
no direct observations.
So how do you distinguish this case from the Worcester versus Holden case, which is
Yes.
similar, right? In fact, it's a domestic violence case. The police weren't observers, right? They weren't recipient witnesses. And in the Holden case, actually, it was 5 years that passed, right, between the incident and so a longer period of time. than
Yes,
the others.
yes. The Holden case it's interesting in that there's a lot of police reports, observations, firsthand observations, hearsay statements nonetheless, but firsthand observations. We don't have that in this case. The officer, we actually have a double hearsay in this particular police report. The officer is only reporting what Goucher said, and 4 days later, Goucher gave another statement to the district attorney's office, which was different, which, by giving that statement, makes the police report, the information contained in the police report, not reliable, maybe articulable, but certainly not credible, because it's only citing one person, and that's Richard Goucher, who says that the event did not occur as the police report had said.
He does speak directly to the police officer and reports the assault.
He does, but the
And
police...
it's not uncommon for a domestic violence victim to recant an allegation of violence, right?
I agree with that, but in this case here, the reason why it's different is that the officer makes no independent information that he saw as firsthand. Because granted, the police report itself is hearsay, but here we have a double hearsay because we have the officer saying something that Goucher said, and the officer either didn't write it down or didn't investigate it to find that anything that Goucher said was so. For instance, there's no marks on Goucher. There's no evidence of the towel, which is the dangerous weapon. There's literally nothing else in the police report other than the actual statement by Goucher himself, which he recants 4 days later.
He is, the responding officer is at the scene, and there is evidence that, I mean, she's there, Dennis is there, he's there, he reports this. It's not like that Goucher came to the police station after the fact and made a statement.
Well, actually...
There's something going on here at the house, right?
We don't know. We don't know who even called the police because it's not indicated in the report. So it would seem that Goucher met the officer in the driveway and then related some information to him. Whether the officer took it down correctly or not, we learned 4 days later that apparently either he didn't or Goucher is unreliable.
Well,
Now-
the later statement clarifies part of the statement that he gave to the officer, but he doesn't recant the part of the statement that she hit him with an open hand, right? And so when we think about the reliability of hearsay evidence, we have a statement here that is pretty detailed. And to me, the fact that he only recants part of it later after further investigation is some indicia that he's being truthful.
Well, here's another problem that we have here. Goucher, in both those documents, Goucher's being quoted. But Goucher, there's nothing that says that Goucher actually saw it, read it, signed it, said that it was accurate. What we do know is that the officer has nothing else to substantiate it. For instance, Goucher mentions that a towel was thrown at him, but he didn't see it because it was toward his back. That's what he tells the district attorney. Now, the district attorney obviously sees he has no evidence to go forward on the case. But here, it's not based on whether she has any criminal record, because she certainly doesn't. It's based on this particular information from an unreliable witness who
But
says
he told
different
the
things.
officer that she continued to hit him with an open hand and shove him after she threw the rag at him. So then he goes and finds the rag and clarifies, in fact, it was not covered in oil.
Right.
But the rest of this statement still stands, right?
I'm not so sure if it does. I'm not sure what he was questioned on and what the conversation was with the district attorney's office. All we know is that he tells them that the information contained in the police report, at least some aspects of it, is not reliable, certainly not accurate, based on what Goucher said. So Goucher is the one cog in this wheel. However, even when you look at that, the statute is interesting because the statute says the determination of unsuitability must be reliable, articulable, and credible that the applicant or the licensee has exhibited or engaged in behavior that suggests if the licensee or applicant or the licensee may create a risk to public safety. There's no evidence here whatsoever that she might be a risk to public safety. It says, or a risk and danger to others, self or others. When Goucher comes there to the district attorney, he's literally, it seems to me, pleading on behalf of her. If that's the case, who's the others? It's certainly not Goucher. And there's nothing here to show that that she's a risk to herself, and certainly no pattern of behavior. 71 years old, no other incident anywhere to show. She has no police involvement, no criminal record, no history of gun issues, and no mental impairment. All it is Goucher saying something, and there's no marks anywhere, at least the officer didn't observe any, or he would have wrote them in the report. So the fact that the report cites some items and Goucher refutes it 4 days later, it's possible that the chief did not know, because both the suspension notice and the discussion with the district attorney's office occurred on November 16, just 4 days after the event. And that was also when the letter first came out to suspend. After the application was submitted, the chief used the exact same reason, saying that the incident report of 22-635, the facts contained in that report, clearly those facts contained in that report are not reliable. They're not substantiated. There's no other evidence there. The police officer saw no crime. Nothing was committed in front of him. He only wrote down, and he's candid in the report, he arrested Nancy Dennis based on the statement by Richard Goucher.
Did you didn't raise your Second Amendment claim in Superior Court?
The Second Amendment claim in here is an as-applied analysis. That's what we're looking at. That
You didn't raise the Second Amendment in Superior Court, correct?
correct.
Thank you.
If there's no further questions, I rest on my brief.
Thank you.
Thank you.
Mr. Bowen.
Good morning, Your Honors. May it please the Court. Richard Bowen, Wareham Town Council, representing Walter Correa, the Wareham Police Chief. This case falls squarely within the line of previous decisions ranging back from the Moyer case that I've cited in my brief and more recently in the Holden-Worcester case. What my brother's case is an attack on the reliability of the evidence that was used by the license authority to deny this license. My brother confutes the fact that the report, that the evidence disfavors his client with the question of whether that evidence is reliable. It is clearly precedent that a licensing authority may rely upon hearsay statements, in this case a police report, as long as that document is considered to be reliable. Looking at the evidence in this case, what would be considered unreliable about this particular document? The officer responded to a complaint of an assault. He spoke with the victim, who stated that he was pushed around, beaten up, swore at, had a rag of hot frying oil thrown at him, and he wrote it down. And that went into the system. And the licensing authority suspended and then later denied an application for renewal of a license to carry.
So the chief's licensing designee, Lieutenant Flannery, said he was unaware of the DA's dismissal of the charges
That's
or the
correct.
recantation, but it was attached to the renewal application.
His testimony was that he was not aware. I don't recall whether he said he wasn't aware of it or wasn't aware of the circumstances of it. To be fair, I'm not sure. I
Isn't
can't.
that important?
I'd say not.
So how does it remain reliable after the witness, the victim recants? And the licensing decision was made by someone who was not aware of that recantation.
Two factors. Number one, he was relying upon the report of one of his officers who spoke directly with the victim. If we were talking about hearsay upon hearsay, listening to what the DA thought about what someone else thought about a case and whether the DA should prosecute that case, I think sounds like totem pole hearsay to me. So which is less reliable? The direct statement?
I think your opponent is correct that there's double hearsay. So let's assume the report itself is reliable in terms of the officer accurately reported what was told to him and what he saw. How were the underlying statements reliable? The underlying statements of Goucher, Mr. Goucher.
Statements made by Mr. Goucher in the moment, at the moment of the assault, I'd respectfully submit that that probably is the best evidence of what occurred, rather than some second thoughts or domestic pressure or matters that frankly aren't in the factual record. They're not in the factual record one way or the other to support either side of the case. And in that regard, I'd like to point out that as is settled in case law, the burden remains on the applicant to prove suitability at all points. And one would think that rather than basing one's case solely on cross-examination of the licensing authority, one could have called Mr. Goucher and said, "Hey, Mr. Goucher, how come you changed your mind? Why did you decline to go forward with the charges?" Now, that didn't happen. And that's the risk that we as trial lawyers undertake when we decide to try our case solely on cross-examination. If you try your case solely on cross-examination, it becomes a very steep hill to climb when the burden of proof is on you to prove that you are satisfactory to hold a license. So it's not purely enough to say, well, Goucher backed off. Why? Was it because he didn't believe it anymore, or he was pressured, or he lied in the moment of time? We just don't have any of that. So going to the subsequent events of the DA's doings, you know better than anyone, DAs have a lot of cases to handle. They have their reasons for doing what they do. None of that's in the record, But what is definitely not in the record is a witness called by the appellant in this case. Ms. Dennis, Mr. Goucher, anyone.
The district court judge and the Superior Court judge didn't say exactly how Dennis is a threat to public safety. Isn't that of concern?
Well, that's, I'll say no. I mean, I understand what you're saying.
But, okay, then why not?
Well, can't one infer that a person who drunkenly assaults someone with hot cooking oil and roughs them up is a threat to public safety? I mean, to me, that sounds like the definition of a threat to public safety. That's not someone I would want around me, but that's just a matter of one old counsel's opinion.
There's nothing that corroborates that the rag had oil, let alone hot oil on it.
The statement of the victim, yes.
That's recanted. That the officer, the licensing authority, Flannery, says he's not aware of that. Doesn't that make it kind of arbitrary?
But is it recanted?
Oh, he recanted the oil assault.
Did he? I mean, the DA didn't go forward with the case. We know that. But does it rise to the
He said it was
level?
water, not oil.
Yeah.
And that his back was turned and he doesn't know what happened.
A very different story than the one he told the officer.
Right, but I guess my point is that the licensing official doesn't even know about, claims he doesn't know anything about the dismissal.
Yes.
That's not troublesome?
He didn't find it to be troublesome. And I believe his explanation, if I remember the record correctly, was that it wasn't troublesome because he didn't know all the circumstances of why it was recanted.
Why shouldn't he reconsider the application now that he knows the information?
I suppose, number one, the lack of a reapplication, but that's a technical matter. Knowing what he knows.
I believe he testified he knew the charges were dismissed.
Yes.
But he was not aware of the statements that Mr. Goucher made to the ADA. The statement that he went and found the rag and noticed it was not, in fact, not covered in oil. And he was not aware of that.
I believe that it was his view that were he to reconsider the application, he would still find that the police report to be reliable.
Okay.
So that's all I have, Your Honors.
Thank you. Thank you both. We'll
Thank
take
you.
it under advisement. Our next case is 24P566, Walker versus Pierre. Ms. Chenevert.
Good morning, Your Honors. Oops. May it please the Court. My name is Dana Chenevert, and I represent the appellant. This appeal concerns two critical errors made by the Eastern Housing Court. The first one is the imposition of a constructive trust over property solely owned by the appellant based on an alleged fiduciary relationship that was unsupported by the record. The second is the denial of the motion for use and occupancy, despite the appellee having resided as a tenant in sufferance for nearly a decade. We request that this court reverse the judgment below and remand with an order to vacate the constructive trust to reinstate the appellant's possession of his property and for further proceedings on the appropriate amount of use and occupancy payments and costs of the appeal, and attorney's fees. So our case law requires that the lower court assess the nature of the parties' relationship and their intent at the time that the property was purchased. In this case, the record reflects that there was no intent for these parties to jointly own the premises when it was purchased in December 2008. Supporting this contention is the appellee's emotional response to learning about the property transaction between the appellant and her mother. She was very angry, and what her anger reflects is a contemporaneous understanding that she was not intended to be the owner of the property. The record reflects an agreement, perhaps to share occupancy of the premises, but never to own it. Also in support of this contention is that the appellee had no involvement in any of the subsequent conveyances. After the initial purchase, the property was conveyed twice. Once to the appellant and the appellee's mother as joint tenants in January 2011, and then again 5 years later, December 2016, to the appellant alone. The record is void of any evidence of the appellee asserting any claim of ownership. And this court found as much when this case first came up on appeal in December 2022. And it arrived at the same conclusion in its March 2023 decision in footnote 11, which says...
Why couldn't the judge credit Pierre's testimony that she believed the premises was always for us and for the kids, and that she wanted to do whatever she needed to do because it was done for the house? Why couldn't the judge credit that?
The judge could credit that, but it was against the weight of all of the evidence. It's distinguishable from the cases that are specifically on point, specifically Sullivan versus Rooney. Now, in that case, the appellant, or the aggrieved party, there was evidence. There was evidence of a fiduciary relationship. That's the case that kind of defines this. Even if we take that the judge credited her testimony, it's not enough to rise to the level of a fiduciary relationship. Sullivan versus Rooney, where essentially the aggrieved party there was a stay-at-home housewife in waiting. She and the defendant were engaged to be married. They had lived together for many, many years. There was an imbalance of power. She gave up her financial independence to cater to and to accommodate the defendant.
She also took care of the house, right? In that case, didn't he move down to Washington, D.C. for a job, was there for about 2 years while she stayed behind in their home, I believe it was in Reading, and took care of the household? Very similar, right, to this case, in which your client was unavailable, right, for a period of time. And so she, Ms. Pierre, was left in the home, caring for the kids, caring for the household.
It's not quite as similar as Your Honor is saying. At the beginning, when they talked, because they had discussions about...
Say they, do you mean...
I'm sorry. Yes. So in Sullivan versus Rooney, those parties had discussions about purchasing a property jointly. He was to purchase the property, and he made repeated promises to her that he admitted to making. The trustfulness, I believe the language in that was that, the facts were established by, the truthfulness is established by his agreement that he had said these things, the defendant's agreement that he had said these things to her.
But didn't Ms. Pierre testify here, and the judge credited that Mr. Walker told her that the house was, in fact, was always, quote, was always ours for us and the kids, and that's in the transcript 9, I believe, page 13.
She did testify to that, but one of the differences here, as opposed to Sullivan versus Rooney, is that Mr. Walker vehemently denied these things. There's no indicia, there was nothing to establish aside that this was true, aside from the judge's credibility assessments, which I know this court just accepts, except for when it's against the weight of the evidence. Now, if we talk about the evidence just very briefly, there is some controversy on the evidence that this court should allow or should determine that's in the record on appeal. We have the testimony from the summary process trial, which the parties had agreed in April of 2023, April 10th, 2023, that they would limit the scope of the evidence that would come in when they briefed the case and submitted their briefs on April 24th of that year, and then also what they would argue May 1st of that year. But then, after they limited the evidence to just what was in the summary process trial, the appellee submitted another piece of evidence. And it's called the defendant's notice. And the defendant, attached to that defendant's notice was a copy of the petition to partition. And this was to support the position that somehow my client had strong-armed the appellee's mother into conveying the property to him. Now, that characterization of the evidence drew an objection by my trial counsel, which the lower court sustained. But in submitting that petition to partition, that triggered my trial counsel to submit another document to the court. So even though the evidence was limited there in April, it seems like appellee's counsel opened the door to further evidence.
Well, except the judge didn't consider any of that. It's apparent from her decision that she only relied on the testimony from the original trial.
Well, I would say it's not clear what the judge relied on, because in imposing.
Well, there are no findings based on any of those documents, so we can't make the findings in the first instance.
Okay, all right. So if that is the case, then, okay, so we're going to limit the evidence to what happened at the summary process trial. But even if we do that and we take her credibility assessments, it's not enough under the case law to establish that a fiduciary relationship existed, or even if we assume that a fiduciary relationship existed, we don't have a finding about the unjust enrichment. We don't have an unjust enrichment, which is also an element that needs to be found in order for there to be constructive trust.
Was the existence of a fiduciary relationship a necessity for finding constructive trust?
Say that again, I'm sorry.
Is it a necessary component of fiduciary relationship for the judge to impose a constructive trust?
Yes. Yes, there needs
What
to be.
What case says that?
I'm sorry?
What case says that?
Sullivan versus Rooney.
And it was absolutely necessary, or there just was one in that case?
It's necessary. It's necessary. And it's in Sullivan versus Rooney. I'm sorry, I need water. So not only do you need a finding of a fiduciary relationship, but you also need a finding of unjust enrichment, which was not found on this case, which couldn't be found on this record, because there is no evidence that Mr. Walker would have been unjustly enriched by retaining this property when he and he alone put down the down payment on this, which was not disputed at the summary process trial. If we go back to footnote 11 from this court's decision, excuse me, dated March 10th, 2023, footnote 11 says, the tenant did not file an answer where any defenses and counterclaims should have been asserted. To be sure, in summary process cases, the right to assert affirmative defenses is not waived when an answer is not filed, citing Morris versus Ortiz-Vasquez. But here, even at trial, although the tenant testified that she took care of everything, she did not, for example, expressly claim to own any part of the premises, to have contributed to the purchase price, to have made mortgage payments, or to have paid for improvements. Nor did she assert that the landlord is anything other than the sole legal owner of the apartment and the building in which it is situated. On appeal, the tenant argues that she asserted a claim for constructive trust. We have some citations, but her unfocused testimony at trial gave little hint of such claim. This is the same body of evidence. If we look at that body of evidence at the summary process trial, this court found that even with those credibility assessments, there was not enough. On remand, the court could have reopened, taken additional evidence. It doesn't make sense to me why that didn't happen when this footnote could be considered a cautionary tale, but she didn't. So what we are left with,
Well, didn't your client's counsel oppose reopening the evidence?
she did. And a read of the record suggests that at that point in April 2023, the case had been ongoing for 3 years. You know, appellee has been represented by pro bono counsel since that time. Meanwhile, my client, coming out of pocket, he had been out of his apartment or he'd been out of his house for 3 years, missing out on rent, which was estimated to be at about $2,900 a month. And then he didn't have the money for what the appellee was suggesting, depositions and further litigation. And so while reopening the evidence would have been helpful, I do understand why, for time expeditious, they just agreed not to. And it was beneficial, it was more beneficial, I believe, for the appellee not to agree not to reopen versus the appellant. But the appellant, he just could not afford that. That's the read of the record. So with the...
Would it be typical for a prevailing party in a summary process action to pay use and occupancy?
I'm sorry?
Is it typical, or is it even heard of, that a prevailing party in a summary process action would have to pay use and occupancy?
No. Well...
And is not Ms. Pierre the prevailing party?
Right. So if I understand the question, a prevailing party on a summary process, okay, would they have to pay use and occupancy? A person who wins?
Yes.
No.
But here you are asking for use and occupancy.
I am, because she wasn't always winning. When the first set of findings came out in March, the lower court ruled in favor of the appellant. I'm sorry, that was December. In the second, let's see, hold on, I'm sorry. So the findings came out, the findings issued December 7th, 2020, findings in favor of the appellant, but the case was stayed further hearing to give the appellee an opportunity to assert her equitable claim. Then when the case came back in, on March 15, 2020, again, the judgment entered in favor of the appellant, at which point the appellee appealed. Now, to renew the motion for use and occupancy, that is, if the lower court found that, her imposition of constructive trust was error, then it was also error not to issue use or not to order use and occupancy payments. And that has to be before the lower court, before it can be before the appellate court. So this is why it needed to be pleaded below.
Before you run out of time, because your brother may mention it, he's certainly entitled to. Your conduct in this case has been, in the filing of your brief, unprofessional, unethical, and irresponsible. And do you want to address any of that? We've struck a portion of your brief. We've struck your 16L letter. Did you want to address to us your conduct in this case?
Respectfully, yes. I feel like I addressed it in the response that I filed with this court on May 1st. Those sentiments still exist. It was a mistake due to unverified research. I had assistance, and quite frankly, I did not check the case law, and I apologize for that deeply.
You are responsible for assistants who work for you.
I understand that, Justice Mead. This is why I did not name names in my response. I am fully responsible.
My point is that it's not the assistant's responsibility to the duty of candor to a tribunal. It's yours.
I understand that, and I mentioned that in my response, and I'm here standing before you today, fully taking accountability for that mistake, having put protocols in place so that this does not happen again. It was not my intention to mislead the court. I've been practicing before this court for the past 10 years, and this is the first time that anything like this has happened, and I do deeply apologize. I am sorry. I am sorry. I hope that it does not take away from the legal issues in this case, which I stand here and argue that, there is not sufficient evidence, even with the parts of the brief that get to stay. And I would hope that this court would look to its decision in March and understand that the body of evidence is the same. There's no unjust enrichment, no finding of such. And we would ask this court to reverse the lower court's decision, vacate the constructive trust, reinstate possession to my client, and remand to a different judge for further proceedings on...
We're going to have to leave it there.
I'm sorry?
We're going to leave it there.
All right, thank you, Justice Mead. Thank you.
Mr. Greer.
Good morning. May it please the court. Colin Greer for the appellee, Julianne Pierre. Your Honors, the housing court in this case denied the appellant Tyrone Walker possession of the premises based on its conclusion that he held the property in a constructive trust for the benefit of appellee Julianne Pierre. That conclusion was based on the housing court's findings, entirely based on the testimony of the parties offered at the original summary process trial, specifically Ms. Pierre's testimony at the original summary process trial, that the property was purchased with the assistance of Ms. Pierre's mother, that Mr. Walker repeatedly represented to Ms. Pierre that the property was, quote, for us and the kids, that during a period of sustained absence, and based on those representations, Ms. Pierre, quote, took care of everything with respect to the property, meaning both her own individual unit as well as the units of the tenants in the multi-unit building. Ms. Pierre also testified that after the relationship deteriorated, Mr. Walker repeatedly harassed her mother, who again was a joint title holder to the property, with the insistence that she eventually sign over sole legal title to him.
So the judge never made a finding about that.
That's correct, Your Honor.
So how can we accept that testimony as true?
Well, Your Honor, she did credit Ms. Pierre's testimony generally with respect to the relationship between the parties.
Well, she was very specific about what testimony she credited and did not credit, and where she doesn't mention that testimony at all, how can we find that as a fact?
I think in some ways it's a necessary finding to reach the conclusion for a constructive trust, and where the judge may have been a little bit imprecise in how she dealt with that issue. I certainly respect that there's a bit of skepticism. But also, Your Honor, even if the secondary finding with respect to, what I'm calling the secondary finding, or the issue with respect to either the harassment of Ms. Germain or the means in which the property came to be owned solely by Mr. Walker, I don't know that that's necessary to affirm the constructive trust here, because in any case, one of the bad act unjust enrichments is the eviction itself, the summary process action. So regardless of the means in which Mr. Walker took to obtain sole legal title to the property, there's still that issue. I would also submit that Ms. Germain is the grandmother of the party's children in this case, and the testimony from Ms. Pierre about the property generally and Mr. Walker's representations to her that it was to be a family property does support an inference that Ms. Germain, even if her relationship with her daughter may not have been well, she was still looking out for the interest of her grandchildren, who are incidental to this case and still live with Ms. Pierre in the property. I submit finally to the court that the facts in this case are very similar to the other constructive trust cases cited both in our brief and in the appellant's brief, including Sullivan versus Rooney and Engler versus Ricard, among others. And because the facts match so closely here, we submit that the court should affirm. I welcome any additional questions.
Seeing none, thank you.
Thank you, Your Honor.
Thank you both. We'll take it under advisement. Let's do another one. Another motion? Yeah. The next case is 23P 1181, Raymond versus Azani. Sobczak. Was I even remotely close to getting that?
Yes, you are.
Okay.
Chris Sobczak. Good morning, Your Honors. May it please the court, Attorney Chris Sobczak on behalf of the plaintiff and appellant Hannah Ramon. This is a case about a young woman who was in a horrific traffic car accident, who then went to a hospital at Haywood Memorial Hospital, And then after about 3 months of care by Dr. Dr. Azzoni, as the agent of the various Haymon entities, was made even worse, permanently disabled for the rest of her life and disfigured. After years and years of litigation, finally in 2022, she got her day in court and was seen before a jury. And after a trial, which the judge incorrectly limited some of the cases that were going to the case, she still got her case before the jury, and the jury found for her and found that the doctor was negligent and that he was the apparent agent or an agent of one of the only remaining party that the parties were about to heard, and awarded her damages. Unfortunately, subsequently, the trial judge nullified the issue twice. First, by applying a cap based on charitable immunity, based on zero evidence that was offered during trial, and then subsequently just wiping out the verdict in entirety, claiming that there was no sufficient evidence to prove that Dr. Azzoni was an agent of the hospital. Therefore, we asked the court to reverse those two rulings and restore the verdict. Subsequently, the case...
Can I just ask two preliminary questions? Your argument about the charitable cap is an alternative argument to your argument on the JNOV, right?
No, both. Because the charitable cap was applied first. So the trial court first took the $3.5 million...
Well, let me ask it this way. If we conclude that the judge was correct to allow the motion for JNOV and directed verdict, we don't need to reach the issue of the charitable cap, correct?
That's correct.
Okay. My second question is, your brief cites the deposition transcripts of somebody.
The 30B6, Mr. Peterson.
Yes. Were those transcripts read to the jury?
Yes, Your Honor. The video was played, but only in part.
The transcripts that we have reflect what was played to the jury.
The transcripts that are in the record appendix are of the entire deposition, and with the court's marking as what was stricken.
Okay,
so the color coding is only about half the transcripts were played, but the record has everything in there. They're not part of the transcript appendix, they're part of the record appendix because they were not transcribed by the court reporters for the trial. They were part of the exhibits that were offered to jury and played. And just to answer the other part of the question, even if the court was to uphold the JNOV issue, there's the still issue of the directed verdict during the trial against the other entity, which then the issue of the charitable cap could still potentially apply. But addressing the specific issues, in this case, the JNOV, the court allowed it by claiming that this is only about issue of employment, and it's not. The Massachusetts law is clear, and as the Fergus Court upheld, that's about agency and not just employment. And it's the conduct and not just words that can present to a third party that somebody is an agent of another entity. And it doesn't have to be directly the third party that you're applying to. And here, there was sufficient evidence for the jury, who are the ultimate fact finders, to decide that Dr. Azzoni was an agent of the hospital.
Okay, so can you talk about that? So what is the evidence that you can point to that was presented that the hospital communicated in any way, either by writing or orally, to your client, upon which you relied, right, in seeing the doctor?
So the clearest evidence is the form. The actual informed consent form that my client was presented to by Dr. Azzoni says Haywood Hospital.
It has the thing on the top.
Correct. There is the building. So there was never any direct testimony as to what was said because my client didn't remember very much of it. And when she was put during the case in chief, the issue wasn't about apparent agency and the trial court's subsequent limiting it to the superior court holding where you have to rely by the plaintiff. It was the controlling law of the Commonwealth. When I presented my case, where it's just agency, you have a conduct or actions that say you are an agent and you're acting within your authority. Here, Dr. Azzoni was at the hospital.
The jury was instructed that there has to be proof that by the hospital's acts or statements, the plaintiff reasonably believed that the hospital provided apparent authority.
Correct. And our argument
so that's
is that
law of the case now. So there has
law
to
of
be
this case.
There has to be some reasonable belief by your client that Azzoni was acting as an agent of the hospital. So with respect to the forms, where's the evidence that she believed, because of the similarity in the forms, that he was an agent of the hospital?
There isn't any, because the instruction was improper.
Because what?
The instruction was improper.
Well, there's nothing, I mean, that was the instruction that was given. You don't challenge the instruction.
We do. We challenged the entire.
Well, you didn't challenge it at the trial, right?
I challenge the issue of the entire case not going to a jury. The issue, the first part about after I rested the case, where the court has ruled that on directed verdict, the agency is not going, limiting it only to apparent agency against one entity, that has challenged, and that's part of the second challenge here.
Right, but as to the hospital, the instruction that was given, was that challenged before the judge?
Yes, it was supposed to be on agency period, not apparent agency. The case was pled and presented as to agency only. The trial court limited to apparent agency only, and the jury still found evidence that ruled against it. But I agree, there is no evidence, there are no words from my client's mouth saying, I believe that he was doctors.
Where is the evidence the hospital directed Dr. Azzoni to use the form with the hospital letterhead?
In the 30% deposition, that's
I didn't
and in the
see that.
forms.
I saw some testimony that he was required to follow rules and regulations, but I didn't see anything specific about the form.
Correct. The rules and regulations says you have to use this form. So one of the exhibits are the specific policies and procedures for consent, and the attachment is the form. So the 30% designee, in the limited testimony that he provided, says that all the doctors have to follow the policy and procedures. The policy and procedures, here is how you do informed consent, and attached to it is the form, and that's the exact form that Dr. Azzoni used. And those are all exhibits in the evidence. So the hospital directed Dr. Azzoni to use their form, present itself as Haywood Hospital. And that's the form that my client saw. And even though she doesn't testify, she testified that she doesn't remember if that's her signature or not, but it looked like chicken scratch, so she actually saw that form. So there is limited evidence. It wasn't something that was fleshed out in detail during the plaintiff's case in chief, because I was proceeding the case under the controlling law of the Commonwealth, not what the court changed it afterwards. But even the little evidence that was there, the jury, as the findings of fact, concluded that Dr. Azzoni was in fact agent of the hospital. Then if you go to the earlier part of the case about the directed verdict, there was also ample evidence that he was even not just an agent, but an employee of the Haywood Medical Group. Because, again, exhibit that's in the evidence is that the employment contract, which was signed back in January, so before he even encountered my client for the first time, went into effect as of April 1st, and he was still treating my client until about April 10th or 12th. And the evidence was that Dr. Azzoni was negligent. Neither myself nor the defendants ever asked for specify what period he was negligent. My argument was that it was a continuing negligence because it was after he removed the cast, after April 1st, when my client says, oh my God, my wrist is so messed up that she wouldn't want to go see him anymore, and the doctor didn't fix it. The damage here wasn't that he incorrectly performed the initial surgery and he cut something off or he killed her. The damage is that he performed surgery in a very backwards and old-fashioned way. It didn't work well, and then he didn't do his duty as a doctor and see that I messed up, I need to correct it. With most orthopedic issues, if you catch it early enough and you correct it, you can prevent long-term damage. Here, he didn't. He did it poorly in the beginning and then stayed in his own way all the way through about April 12th, while he was already an employee of the second group, and hurt my client. So that was the second issue of the directed verdict. On the issue of the charitable cap, there was zero evidence offered by the defendants during the case for which the court could consider how to even apply case. Almost identical issue was just before this court a couple years earlier in the Larkin case. And ironically, it was the same defense lawyers that had the defendants in the Larkin case and in this case that failed to offer evidence during trial. Here, the same thing is they offered nothing during the case. Afterwards, the judge said, well, we'll handle it, and they submitted evidence. They submitted an affidavit, they submitted documents. Had this been done during trial, one, I would have a chance to cross-examine them. Two, we would have potentially had an issue of whether or not the issue of this defense is addressed by the jury or a judge.
The problem in Larkin was that it wasn't pleaded as a defense, and you agree, it was pleaded as a defense here.
Yes, but that was an assault problem. That was one of the problems.
That was the primary problem. How was the procedure employed by the judge here different than what was employed in Goldberg?
Because here, the judge did not, during trial, say, I am bifurcating this case.
Why does that matter?
Because
how is there any prejudice from the procedure that the judge used?
my clients were denied their right to cross-examine. My clients were denied the right to, by Constitution, 7th Amendment of the U.S. Constitution, 15 article.
Specifically, what is the specific prejudice? What could they have offered at trial that they were not allowed to offer?
evidence, which we had none.
What kind of evidence?
Cross-examination of the person that testified. If we tie it into actually the fifth part of the case, the
How would it
30b6
have made
deposition.
any difference on the ultimate determination of whether the charitable cap should apply?
Because the charitable cap is a three-pronged factual finding. Here, the court did not make any rulings on the three elements. He just said allowed. So we don't know if the judge just blindly accepted what the defense offered without any evidence of cross-examination. I didn't have a chance to cross-examine them. I didn't have a chance to offer my evidence. If we tie into litigation, this is a trial. We have discovery. During a 30b6, we asked the defendants, give us the facts to support your affirmative defense. They gave us none. We went before the court to compel. During the arguments, defense counsel literally said, I have nothing else. And in the order that the court denied the motion to compel, it says, and as to affirmative defenses, defendants conceded they have nothing else. So had the procedure from Golden been used, and we were actually bifurcating and have a trial, one, we would have a chance to argue with the court whether or not that trial should be before a judge or before a jury, because my clients have a right to a jury trial on their issues, which includes affirmative defenses. And two, I would have moved in limine to preclude the defendants to offer any new evidence, since they didn't offer any of it during discovery. None of that happened here. There was the trial ended, all the exhibits were before the trial, the evidence closed, and the court did not say, we'll address the evidence later. Even when the issue came up, defense still didn't move to reopen evidence, we will address it. The court just took evidence that was submitted after trial without any opportunity for the plaintiff to cross-examine it or counter it, and just ruled saying motion allowed. Doesn't say which three elements were met, doesn't say how, if anything, was considered differently. Defendants argued that the articles of organization can be prima facie evidence of charitable cap. Well, even those were never offered during trial. The person for whom they offered the exhibit and the affidavit was on the witness list. He was on the witness list by myself and for defense counsel. They chose not to call him. They basically, as in Larkin, they fell asleep, they forgot to offer any evidence, and then afterwards they used a judge that allowed them to get it in, which that's the error. The evidence should happen at trial. And with that, the other issue of the 30b6 is, there's lots of issues, but the one primary that's most important to this issue is the one dealing with the evidence of the affirmative defenses, which would have tied into the issue of the charitable cap. And if there are no other questions, I'll rest on the briefs.
No, thank you.
Thank you.
Ms. Galiletis.
Good morning to your honors. Amy Galiletis on behalf of the three Haywood entities that are the subject, and I represent the appellees. There are, as I see it, two major issues that we're discussing here. One is the involvement of the Haywood entities as parties, whether or not they should have been dismissed or judgment rendered for them at certain points, and the other issue being the issue of the charitable cap. Unless your honors would like to directly ask me questions, I will handle the issue of the JNOV/directed verdict first, and then the charitable cap. With regards to the directed verdict ruling by the judge was directed towards two of the Haywood entities, that being Haywood Hospital and Haywood Medical Center. It is not disputed at any point that Dr. Azzoni was never an employee of either Haywood Hospital or Haywood Healthcare. Haywood Healthcare is actually an entity that does not employ any individuals. But with regards to Haywood Medical Group, that falls under a slightly different category here. And the reason for that is because Dr. Azzoni did become an employee on April 1st, which would have also been the date of the last post-op appointment with the plaintiff in this case.
How do you respond to the opposing counsel's argument about how it was an ongoing, it went all the way until April 12th that his care, the doctor's care of his client? I know that he had that appointment on April 1st in which they went over the x-ray, and there was acknowledgement that, this is not, I believe the doctor referred him to PT, right, physical therapy. And then that was it.
And perhaps, if memory serves, in a nerve conduction study. That may have been part of that visit, their recommendation as well. And, Your Honor, this is how I would answer that. In order for HMG to be vicariously liable, not only does employment have to be proved, but scope of employment has to be proved. And in this particular case, Dr. Izzoni testified at length that at the time of the first contact with Ms. Raymond at Haywood Hospital, he was not an employee of HMG, of Haywood Medical Group. He was an independent contractor. He also testified that the treatment, if you will, or the scope of contact that he had with Ms. Raymond was also as an independent contractor. He was subject to what they refer to as universal or global billing, which indicates that he, as an independent contractor, charged Ms. Raymond as an independent contractor and for the entirety of the treatment that he rendered to her, both the surgery as well as the postoperative treatment. And when he testified at trial, he made it very clear that all the appointments and all the recommendations were pursuant to that global treatment, if you will, as an independent contractor. So the way that I would respond to Your Honor's question is that in this particular instance, while he was technically employed, Dr. Izzoni was technically employed by Haywood Medical Group on the same day as the last time that he saw her, his treatment of her was not within the scope of his employment on that one day. I would also note respectfully for the court that the complaint issued by counsel in this case discusses specifically the surgery. Does not make any allegations that specifically what the treatment was on April 1st was negligent. What is pled in the complaint is that the surgery was negligent.
Well, it refers to follow-up appointments and x-rays and says that Dr. Izzoni failed to recognize that it wasn't set properly. That goes to after he got the x-ray, which was April 1st, right?
It does, but again, what I would, it can be inferred to that point, yes. I would have to concede that point. But in this particular instance, again, with regard to the scope of employment, the treatment that was rendered, the entirety of the treatment that was rendered by Dr. Izzoni to Ms. Raymond was when he was an independent contractor and not part of his employment with Haywood Medical Group.
So after April 1st, was there any contact between her, the patient, and Dr. Izzoni?
My understanding is that she never went back and that she did not follow the recommendations by Dr. Izzoni after the last time he saw her. That is my memory. I would say that I was not trial counsel in this case, but that is my memory.
So are you saying then that even, let's say she went back and on, May 1st and had another appointment, that would also be under the scope of his independent contract?
Yes. Yes. Because
So the entirety of his care?
Yes, the entirety of his care. So when he testified at trial, he made it clear that he was, at the time of the surgery, not an employee of Haywood Medical Group, and that pursuant to his treatment, and which was evidenced by the billing, and quite frankly, it was also indicated by the fact that Haywood Medical Group, there's no evidence that Haywood Medical Group ever asked for or sought reimbursement for any fees, because if the employment agreement between Dr. Izzoni and Haywood Medical Group was entered as an exhibit at trial. And it was very specific that any treatment that was rendered by the physician pursuant to his employment, that any fees, any payment would be collected by Haywood Medical Group. There was no fees or payment that was collected by Haywood Medical Group, and Haywood Medical Group did not, to Dr. Izzoni's knowledge, and there was no evidence at trial adduced to this point, that they ever sought reimbursement for what they may have seen as treatment that was rendered during the scope, supposedly, of Dr. Izzoni's employment.
Let's assume, just hypothetically, we disagree with you on this point.
Mm-hmm.
What can be done given the bankruptcy?
I'm sorry, what can be done given?
What can be the remedy given the bankruptcy? So there can't be a new trial, right?
Well, with regards to the bankruptcy, Haywood Hospital has now emerged from bankruptcy.
Emerged from bankruptcy. So there can be a new trial.
There could be. I would, yes. To directly answer your question, Your Honor, yes. There could be a new trial.
Against any of the entities?
Against any of the three entities, yes.
Okay.
Because it emerged from bankruptcy back in September of 2024.
Okay.
To continue with regard, if there's no further questions on those points. No, okay. So with regards to Haywood hospital, again, there is no evidence that Dr. Izzoni was an employee of Haywood Hospital. Now, as I'm sure this court well knows, under the Diaz case, under the Hohenleitner case, and my apologies if I mispronounced that, the definition of agency and apparent agency shifts somewhat under the umbrella of medical malpractice cases. The plaintiff has to prove that the entity, so in this case, what's being argued is the hospital has, any entity has to prove they have power and control over the doctor's professional conduct, and in this instance, the treatment. In this case, there is no evidence of that. While plaintiff's counsel is trying to put before the court that forms could be evidence of some sort of apparent agency, he does not cite any case law for that proposition. There are cases which indicate other signs of apparent agency, such as the wearing of IDs that have the hospital's name on it, such as wearing lab coats with the hospital's name on it, some sort of outer showing on the person of the physician that they are acting in apparent agency of that entity, but that does not exist here.
But if the patient's signing a consent form and it says Haywood Hospital on the top of it,
Yes.
is it not reasonable that the patient would think, oh yeah, that's, this is related to the hospital? Like, how do you directly address?
The way that I would address that, Your Honor, is that first of all, as I said, I am not aware of any case law that stands for the proposition that a form would be sufficient on its own with no other evidence and with a lack of reliance by the patient is sufficient. What I would also say, Your Honor, is that that form, by that same logic, any person that comes in and out of the hospital that is doing any sort of professional work, it could be janitorial staff, it could be repair people coming in, it could be tech support. By that argument, plaintiff's counsel is trying to suggest that anyone who is in the hospital for a purpose other than treatment is an agent, quote unquote, of Haywood Hospital. And there's quite frankly, as I'm aware, no case law that would support that proposition. In this particular case, Ms. Raymond was actually somewhat contradictory in her testimony of what she remembers from conversations with Dr. Izzoni, specifically during the time that she was in the hospital, post-visit when he was treating her broken wrist. Whether she remembers it, whether she doesn't remember it, there's no evidence whatsoever from her that she relied on what she saw on this form or even recognized what she saw on this form as being an indicator that everyone within the hospital, including Dr. Izzoni, was an employee. Did that answer your question, Your Honor? Okay, thank you. I would go on to say that in this particular instance, again, there is no evidence that Ms. Raymond relied on any evidence whatsoever that the Haywood entities employed Dr. Izzoni. I would also, if I could, take issue with part of what plaintiff argued, because the trial judge in this case was clear during the, I believe, the first or second day of impanelment, that in the presentation that had been made to him thus far, that he did not see any evidence of the connection between the entities and Dr. Izzoni in the way such that vicarious liability could be sustained. So while that's not dispositive, plaintiff was put on notice that a careful showing needed to be made in that regard because the trial judge already had concerns about whether or not they would survive a directed verdict. And quite frankly, as was shown by the judge, there was no evidence here. There was no evidence of reliance whatsoever. I would like to point out for the court, if I could, in plaintiff's brief, in the appellant's brief, there are cases that are cited that I would suggest do not stand for the propositions that they are cited for in the brief. I would specifically draw Your Honor's attention to Fergus versus Ross, which is 477 Massachusetts 563, which is a 2017 case. I would respectfully point out that the appellant mistakenly relies on that case for two reasons. The first being is that Fergus does not stand for the proposition, as argued in that brief, that reasonable reliance is not a requirement. There is nothing in the Fergus case at that site that indicates that that's not a requirement. I would also point out that in appellant's brief, it is argued that Fergus, in essence, takes the requirement of contact between the third party and the principal as being a requirement. However, in this particular case, what it does say in Fergus is that while the direct contact isn't necessary, it does have to be ratified by the principal. And in this particular case, there's no argument from the appellant that the conduct was, Dr. Rizzoni's conduct was ratified.
Well, he says the hospital required him to use the hospital's forms.
Forms, yes.
Right, so
But there's no indication.
that's ratification, right?
I apologize.
That's
what?
ratification, right? What if the hospital said, use our forms, wear our coats, use our business cards?
Yes.
That's ratification, right?
I would argue that it is not. And the reason I would argue that is because in this particular case, again, that was never communicated to Ms. Raymond in any way.
Right, putting aside the reliance issue, though, he's correct that the communication doesn't have to be direct, as long as it can be traced back to the principal. So if the principal is directing, the hospital is directing Dr. Rizzoni to use all of its stuff, that seems to me to be enough, at least with respect to that element of the claim.
So I would agree that it does not have to be direct. I would agree that it has to be ratified, and it has to be ratified in my reading of that case law, that it has to be ratified by the patient being made aware, basically the other party in that contract needs to be made aware that that is a requirement. But there's no communication, there's no evidence of communication here. If I could, I will refer next to the charitable cap, given that I see that I'm running out of time. In this instance, I would again take issue with the appellant's argument. There was evidence adduced at trial of the Haywood entity's charitable status. Those were actually in 3 separate exhibits: trial exhibit number 8, number 10, and number 23, which were an agreement with Dr. Rizzoni, the bylaws of the staff of the hospital, as well as filings with the Secretary of State, all indicate the Haywood entity's nonprofit status pursuant to Section 85K. I would also point out in this instance that, as was pointed out previously, that the issue in Larkin was the pleading of the affirmative defense, or the limitation in that case. There's no argument whatsoever here that it was pled properly, and the judge made it clear that he saw this as a post-trial issue. He entered that in the court record, the docket, twice, that he considered this a post-trial matter, and that is how it was pled, and that is how it was argued. Thank you.
Thank you. Thank you both. We'll take it under advisement. We're going to take a short break.
reopened. Please be seated.
Our next case is 24P 1191, Zamora versus Streeter and others. Mr. Gaddis.
Thank you, and may it please the court. We are here on an appeal of a tribunal decision in a medical malpractice case. I won't belabor the medicine unless the court has any questions, but basically in a medical malpractice tribunal, as the defendant has conceded in the brief, the plaintiff was only required to evidence three factors: that the defendant is a provider of health care, that the physician's performance did not conform to good medical practice, and that the damages resulted therefrom. The key there is that the plaintiff need only evidence it. The plaintiff need not prove it. It's not a trial. It's not subject to cross-examination or conflicting evidence. The case law supporting that is decades old and consistent. That's not what happened here. So I want to go through element by element as to why I think this is a very straightforward appeal. The first is simple, that the defendant must be a provider of health care. I don't think that's disputed. I don't think it could be disputed. He was a surgeon who operated on the plaintiff's scene. The third is that damages resulted therefrom. That was supported by the causation opinions of two different qualified experts, both a cardiologist and a surgeon, who opined that but for the deviations identified from the standard of care in their expert letters, more likely than not, the patient would have survived, as she ended up suffering cardiac failure due to a clot that formed in her heart as a result of a clot forming due to insufficient anticoagulation when she had a mechanical heart valve that was known. So everything in this case comes down to element number two, the evidence that the physician's performance did not conform to good medical practice. And that, I think, is where the problem arose here. Because as the court is likely aware from review of the briefs, the plaintiff presented two expert letters that identified 14 separate deviations from the standard of care.
And they're identical.
They are, yes.
Both expert witnesses, supposedly separate and apart from each other, wrote letters that were completely identical, that draw no distinction between Kruger and Streeter whatsoever.
As to the identicality of the letters, that obviously has to do with the method of their drafting. But with regard to the distinction between Kruger and Streeter, that is correct. The experts did not find a distinction between them. Kruger and Streeter are both board-certified surgeons. Kruger himself actually ends up being the head of the bariatric surgery department there. He was not an assistant in the traditional sense, in that he was not a resident, he was not a student.
He didn't have anything to do with the failed attempt, right?
He did not, and I don't believe...
And he was brought in because of the extensive adhesions, right?
Correct.
Help me out, because I'm not a doctor.
So my understanding, and I'm not either...
It's scar tissue?
This comes from the experts, yes, that's largely scar tissue from previous surgeries. In an abdominal surgery, especially with a woman, it can often be from cesarean section, hysterectomy, or anything of the sort. But adhesions and scar tissue can prevent easy completion of an abdominal surgery otherwise. And so a second surgeon is brought in because Dr. Streeter does correctly realize he needs a second surgeon. This is not somebody who's holding a flashlight. This is a surgeon who is brought in, and he is a bariatric surgeon. This is his specialty.
Right.
And our experts have both stated that the standard of care for a bariatric surgeon performing this procedure on a patient with an artificial heart valve who is known to have a risk of clotting and is on chronic anticoagulation.
So, but the negligence you're alleging is the failure to properly manage the anticoagulations.
Both pre and post-operatively, yes.
Right.
The surgery itself is
and does either expert offer an opinion as to Kruger as an assistant failing the standard of care in the anticoagulation?
Well, I want to distinguish there because, yes, both experts do, in fact, offer an opinion
that differs from Streeter, who was the head surgeon.
No, it doesn't differ, and that's the point here. Because the standard of care is not a question of opinion. As the Palangian court made very clear, it is a statement of fact made by the experts, but it is nevertheless a statement of fact as to how physicians practice medicine. Both experts agree, and must be accepted as true at this phase, because all evidence must be accepted in the light most favorable to the plaintiff, that the standard of care required both surgeons, any surgeon performing this surgery, to properly ensure that the anticoagulation...
Wouldn't you need one of the experts to opine that Kruger had to countermand the alleged improper anticoagulation care?
No, I don't think so.
Why not?
Because, for one, he participated in the anticoagulation itself. That is, the claim that he had nothing to do with it is not supported by the records. There's a visit between the two surgeries that both Dr. Streeter and Dr. Kruger participate at which, recognizing that there's been a delay since she was taken off for anticoagulation, the decision is made to give a single dose of weight-based Lovenox. According to our experts, that was not a sufficient dose. It was not a loading dose. And more importantly, her INR was not checked and not found to be at a therapeutic level before the surgery was performed. Second, there is one separate criticism of the second surgery that has nothing to do with insufficient anticoagulation, and it's that it was unsafe to proceed. This is a situation where a cardiac clearance was requested and obtained for 5 days. The cardiologist in this case, who's a defendant but not an appellee, gave the patient 5 days off her warfarin and said you can safely proceed at that point without a Lovenox bridge. Now, we've challenged that decision as well, but that's not before this court. The claim, however, is that these two physicians, Streeter and Kruger, relied on that clearance. That claim was raised at the tribunal, it was raised in the Rule 73 demand, and it was argued at the tribunal. That's simply not factually correct. The clearance was for 5 days. The surgery occurred 7 days after because it was aborted. They didn't go back for a new clearance, and that's what our expert says they had to do. And had they done, the cardiologist more likely than not, and he in fact...
They're not cardiologists, right?
No, they're not, although they don't have to be to understand what their obligations towards their patient as a surgeon are.
It was unreasonable for them to rely on Dr. Ravino, who was the cardiologist, what his opinion was.
Our expert hasn't said that it would have been unreasonable to rely on the cardiologist if the cardiologist's advice had actually been relied on, but they deviated from it. They didn't go back when they had deviated from the plan, and our expert has not been asked, and I don't actually know how he would opine, neither of our experts, as to whether or not they would proceed. I suspect our surgical expert would say, this is a patient without a therapeutic INR, she goes through surgery, you need to get her up to a loading dose of warfarin or Lovenox right after her surgery, as in fact both experts say was required after the surgery. And the simple fact of the matter is, we're not talking about duty here. The duty is established under the law, is that every physician has a duty to their patient to treat their patient in accordance with the accepted standard of care. Standard of care is a question of scope. It's a question of fact. There's no question that Dr. Kruger had a duty to his patient. He operated on her. I doubt he would ever dispute that. They're questioning whether or not his duty included anticoagulation, and our experts have stated in multiple letters, both from a cardiology perspective and a surgery perspective, that as a factual matter, the standard of care required not operating on a patient with a subtherapeutic INR who had not been properly anticoagulated, and if one goes ahead, immediately loading her up with a loading dose of warfarin afterwards.
Why isn't Kruger like the emergency room doctor in the Cooper case that your brother spends quite a bit of time on and you don't even mention in your reply brief?
I don't think the Cooper case is relevant, Your Honor. I mean, Dr. Kruger here is he's not somebody who's tangential. He's in the operating room. He's in the operation. He performs the operation with Dr. Streeter. He is as hands-on as he can be. The only way it ever came up, it was not raised in the Rule 73 tribunal demand, it was not argued by Dr. Kruger's counsel, that there is supposedly a distinction between the scope of duty of these two physicians is that the medical member at the tribunal introduced his own opinion on the record, contradicting the plaintiff's expert's opinion.
But we said in Cooper that's not the tribunal's decision.
It's not a tribunal decision, no. It's not.
Not the basis of their decision.
It certainly appears to be because it was not argued and was not briefed.
But it's not. In other words, it can't impugn or impeach the decision that's made in the form. As we said, any more than oral argument at this case is any indication of the rationale of what we ultimately decide.
Because there's no distinction in the facts between between Streeter and Kruger, except that statement by the medical member that the medical member believes the standard of care.
The demand itself says that the opinions fail to appreciate the various roles of the multiple clinicians involved in the decedent's care during the relevant time. So it seems to me the issue was raised.
And nothing beyond that, Your Honor.
All right.
As to that distinction, that language is cut and paste into every single Rule 73 demand.
Well, regardless, you said it's not in the demand. I think it's in the demand. And the main difficulty I'm having here is that in viewing that records in the light most favorable to your client, it is quite evident that Dr. Streeter and Dr. Kruger had different roles, and Dr. Kruger's role was far more limited. And the opinions, as Justice Mead pointed out, are exactly the same as to both. And it seems that they even opined that Kruger was responsible for things that happened relating to the first surgery before he was even involved. So how the opinion seemed to me to be deficient in that respect.
To the extent that the opinion may be erroneous on a particular criticism, and I won't challenge that if that's the court's reading, the case law is very clear. The expert need only have a single criticism that is supported by the evidence. The question is whether...
It's indicative that it was a cut and paste without any consideration of the different roles that each professional played.
Your Honor, with all due respect, that's an evaluation of the weight of the evidence, which the tribunal is not permitted to do, and respectfully, this panel is not permitted to do. The statute
We can review the adequacy of the expert opinion, though.
Not the weight. The adequacy is a separate question. The standard as to whether the expert opinion has to be accepted has been set out by this court multiple times. It must be accepted unless
It seems that there was no effort made whatsoever to differentiate Kruger from Streeter.
Again, I respect that characterization, and I think it is correct. However, I think it relies on a predicate that our experts do not agree with. Our experts are of the opinion that the standard of care required the same of them, at least from the
Telling us that these experts independently came up with exactly the same language.
No, they did not write the language. I'm not going to pretend that they did. However, they do share the same opinions. They have adopted it, they have signed it, they will testify to it at the time of trial, and they are available. And they have to be accepted as true at this phase. There's no requirement anywhere in the tribunal statute or in the case law that the experts handwrite their own letters. That's never been held. But they've adopted these opinions, they express these opinions, they're qualified, their qualifications to express these opinions have never been challenged, and they have to be accepted as true unless, and the case law says, they are not so deficient that no reasonable court could admit them. And that is an extraordinarily high bar that, frankly, I don't think this court has ever upheld since it announced it. It has never kicked out an expert opinion at a tribunal based on that deficiency.
You're correct, of course. They have to be accepted as true, but they don't have to be accepted as adequate. Regardless of weight, if there's no opinion in there by either Gore or Edelman that Kruger, in his capacity as the assisting surgeon, deviated from the standard of care required under the circumstances in this case.
That is the characterization, that his capacity as an assisting surgeon changes the standard of care, and that is not a fact agreed to by our experts. Our experts are very clear. These are two board-certified surgeons participating in this surgery together. Kruger wasn't there because someone needed someone to hand him forceps. He was there because this was difficult surgery that required his expertise. And at that point, he has a medical duty to the patient. The scope of that duty has been established since the 60s. The scope of that duty is to meet the accepted standard care for the average qualified surgeon in his position. Our experts have evidenced what that is. That is a question of fact that the tribunal and this panel are not permitted to reject. If that fact wants to be challenged by the medical member, the defendant's experts, or anyone of the sort, that is a question for trial. The weight of that opinion, unless it is so deficient that no reasonable judge could admit it, and I would contend that that would not be an appropriate finding here, and it was never even argued at the tribunal level that that was the case, it can't be disregarded. But I have to stress, this was never raised by the defendant at tribunal. Also identical to the criticisms of Dr. Streeter and Dr. Kruger are the responses of Dr. Kruger and Dr. Streeter. They're jointly represented. They responded with the same oppositions. They claimed they relied on the cardiac clearance. That's factually incorrect. They claim that it was reasonable. Reasonableness is a question for the jury. They claim that the patient assumed the risk of the procedure, that defense is prohibited by statute. And they largely claim that they used their judgment and they gave Lovenox, but our expert says that Lovenox was wildly insufficient because its effect wasn't measured and it wasn't a loading dose. These are all disputes of fact that were raised in the Rule 73 demand and Dr. Kruger's argument. The only person who argued on Dr. Kruger's behalf in this fact is the medical member who was not a testifying witness and is not permitted to substitute his medical view for that of the plaintiff's expert.
It's your client's burden at the tribunal.
It is, and
So they didn't have to say anything.
They did not, no.
Okay.
And had nobody said anything, I would contend that this tribunal would have gone straight forward. As the judicial member clearly understood in dissenting from this decision, the facts before the tribunal, if accepted as true, required a finding that for the plaintiff with regard to Dr. Kruger. The only way this ruling could possibly have distinguished between the two physicians is if the only factual distinction made by anyone was accepted, and that was the medical member's distinction, claiming that a separate surgeon did not have an obligation to anticoagulation. Both of our experts say that he did. That must be accepted as true, and that is the standard this court has set out countless times, most recently in Feliciano. And I think I'm out of time. Thank you.
Thank you. Mr. Huck.
Good afternoon, Justices. May it please the Court, I'm Dayton Huck on behalf of Dr. Kruger. I ask Your Honors to uphold the decision of the Medical Malpractice Tribunal below. After reading the reply brief, the elephant in my corner was that trial counsel or counsel below didn't raise that there was no evidence of the standard of care. I did not find case law responsive to the plaintiff's argument on that, but I did notice that Your Honors have discretion to review that argument, so I'd ask you to do so. And I think it's important because we're working with a directed verdict standard here, and so this court will be reviewing the sufficiency ultimately in any regard. The next concerning part after the reply was with the plaintiff's reading of the facts. They have a very deferential standard here. They do get the benefit of the facts as their, I'm sorry, Your Honors. They get every reasonable inference in their favor. And it's a reasonable inference. It requires some fact to uphold it. One of the places that I took issue was in footnote 2 of the reply brief, which had this, drew a parallel to the Gugino case in which the plaintiff said that there had been a phone call. And the reply from the defense was, well, look at the medical records. There's no evidence of a phone call. And so the court replied, well, you're missing the point. The evidence exists, and we have to take it in the light most favorable to the plaintiff. But here we don't have that. We have the medical record, but an absence on the plaintiff's side about what happened with Dr. Kruger that was related in any way to anticoagulation. So the record appendix on page 150, it's that after discussing with the patient, her family, and doctors Kruger and Streeter, a plan was made to get CT abdomen and pelvis and then reattempt. In the interim, she was given a single dose of the anticoagulant. My brother reads that as implying that Dr. Kruger had some relation to the anticoagulant. But those two sentences are written by a PA who's summarizing after, and it doesn't say anything that Dr. Kruger had to do with the plan. If it had said—
I was actually going to ask you about that, because I read your brief to be conceding that Kruger did meet with the patient and her family before the second surgeries, but now you're saying you're not conceding that.
Oh, no, Your Honor, I do concede that. What I don't concede is that the proximity of the two sentences indicates that Dr. Kruger—
How do we know that he met with the family before the second surgery?
That is my understanding from this sentence, that it was a meeting with the patient and her family.
It's the PA is the physician's assistant is writing it, right? And it says, after discussing with the patient, her family, and doctors Kruger and Streeter, a plan was made. That seems to be very vague to me. Who's discussing what with whom? I mean, right? So,
yes.
But you read that to mean that Kruger did meet with and discuss something with the family and the patient?
I see the point that Your Honor is raising, which
right?
is—
I mean, not to get all grammatical, but this is the problem with dangling modifiers, right? After discussing with the patient, a plan was made.
And your point goes to Dr. Kruger. And that's kind of— I mean, if you took it in that light that I was mistakenly suggesting, you still don't get there. You're getting a conversation about a second sleeve, and no fact to kind of suggest that that has to do with the anticoagulation. That is really the place where there's the hook missing for the plaintiff. I thought that he was going to quote Record Appendix on page 124, where the PA is again writing, the patient is continued on heparin, Coumadin, discontinued. Dr. Streeter and Dr. Kruger, who's on call tonight, are aware and agree. I thought that the plaintiff was going to bring that statement up because it is really another close place between anticoagulation and Dr. Kruger, my client, who I'm saying has no relation to the anticoagulation. But the inference you can draw from that reasonably is what it says, that he knew about the anticoagulation plan. That doesn't mean that he has some active role in it. So on the standard of care, I'm asking you to find he didn't have one. And I'll continue to the breach argument if there are no questions.
What about the experts' opinions that it was negligent to perform the second surgery without having the patient reevaluated, or alternatively by delaying the surgery for 1 to 2 months?
My understanding of the complaint is that those surgeries are not challenged as the surgeries, but only as they relate to the anticoagulation and that plan. So I wouldn't concede that Dr. Kruger was being alleged as negligent for that second surgery.
Okay.
If the expert opinions are identical, which I don't think anyone disputes, and it was sufficient for Dr. Streeter, why is it insufficient for Dr. Kruger?
Because of his side role. He comes in for adhesions, and other than a conversation, well, possibly a conversation with the families and being aware of the plan, he is absent from these records in relation to the challenged procedure, which was a failure to correctly manage the anticoagulation. So without a closer proximity, he is far more like those cases where it's you're admitting a patient or administering medication under the direction of another. It's not where he's authored a note showing that he exercised independent medical judgment. There's nothing to suggest he exercised any judgment regarding that plan. That's at the heart of the problem that the plaintiff has. I don't have more to say, Your Honors, than that. I'm happy to field any questions.
Seeing none, thank you. Thank you both.
Thank you, Your Honors.
Take it under advisement. Our last case is 24P659, Pritzky and another versus R.J. Reynolds Tobacco Company and another. Mr. Rayner.
Good morning. I'm Andrew Rayner from the Public Health Advocacy Institute in Boston. I represent the family of Joseph Pritzky, who are here, and along with my co-counsel Meredith Lever and Lenny Keston. We are here to ask Your Honors to reverse the judgment for defendant. We were precluded from introducing so much of our evidence in this case that we couldn't meet our burden of proof on negligence, conspiracy, or breach of warranty. As Your Honors, as this court ruled in 2016 in Albright, relevant evidence should be admitted unless there is a quite satisfactory reason for excluding it. The trial judge in this case applied the opposite principle. On our claim of negligent marketing to minors, the trial judge excluded every single company document that expressed the intent of R.J. Reynolds to market to minors. How do you know that with this huge trial record? You know that because our capable opponent has submitted a supplemental appendix to you in which they claim the trial judge admitted 105 pages of evidence on this subject. And I urge your honors, this is rare, but I urge you to please read his supplemental appendix, because you will not find one word in any of it that expresses the intention of Lorillard or Reynolds to market to minors. Not one. There are two, what you'll find there are two opinion polls, one conducted by a competitor of R.J. Reynolds, and the other, in the other poll, the opinions of minors that are elicited are things like, why do minors quit smoking? There's nothing in there that expressed the intention of R.J. Reynolds. By contrast, I ask you to please also read pages 18 to 20 of our opening brief, in which we documented the specific memos that said things like, we must get our share of the youth market. That's RA2, page 1267, second volume. The base of our business is the high school student, second appendix 1160. We marketed Newport as a fun cigarette for an immature audience, RA2 2861. And contrary to the argument that's been made to you, we documented where the trial court, for each one of those on pages 18 to 20 in our brief, we documented exactly where the trial court excluded it, and we documented where we preserved the record, because we were allowed to submit Exhibit K for identification, which begins on page 2850 of the second appendix, and you will see there every single one of these documents that I've been referring to that were excluded.
I was able to find the documents. What I found missing wasn't any not across the board, but for many of your objections, an analysis of the judge's reasoning for excluding each of these documents. So your burden is to show abuse of discretion, so how can we find an abuse of discretion when you don't address the judge's reasons?
Well, Your Honor, often there was no reason. Very often there was no reason, and in some cases, and in most cases, I believe, we do address the reason. The primary reason given by the judge, and again, respectfully, if you look at sometimes we switch them, unfortunately, but normally it's the first record appendix cite to the volume 2 that shows where it was excluded and the discussion there. The judge basically excluded them because she said words like youth, teenager, and high school student were ambiguous, and she could not conclude from that that referred to minors, where the claim is negligent marketing to minors. Then we found 3 documents that actually said that they were talking about 14-year-olds and up. And she then excluded those 2. My brother objects that
Because there was an attachment missing, right?
Yes, on one of the 3 documents, Your Honor.
Well,
I respectfully ask you to look at the discussion on page...
I did. So you grouped the documents together at the judge's request, and then defendant's counsel says the documents all present the same issue, meaning the attachment is missing, and that's the reason the judge excluded them.
And Your Honor, if you will, I do respectfully ask you to please look at, I'm going to get it for you precisely, page 1327 of the second record appendix, where I asked to be heard on that distinction. I asked to be heard that the attachment was missing from one of the documents and that we had complete copies of the other 2 documents that said 14 to 24, and she said, I have ruled, Mr. Rayner, that's it. So I did, respectfully, I most certainly pressed this. And again, this is not a case where the court excluded 1 or 2 documents. It's not a case where the court even excluded 10 documents. She excluded every single one of them. And as I say, the defendant has made a submission to you where they say she admitted this evidence, and I'm asking you to please look at what they submitted, because you will see it's not there. With respect to the other arguments that I didn't address the judge's ruling, I would like to point out multiple places in the record. All of these are in Volume 2, which has the whole transcripts. I just pointed out 1327. Once I've ruled, I've ruled. Page 496. Your Honor, may I just try to convince you on one thing? Answer, no. Page 631. May I be heard briefly? No. Page 639. On page 639 is where the judge excluded 2 documents about youth marketing that were part of a deposition of a corporate representative. She gave no reason why she excluded the documents. We did point this out in our brief. We did troop through in our brief. I believe in the opening brief we did troop through reasons for why each of the documents were admitted. And with respect to those 2 documents, page 639, she gave no reasons. She just wouldn't put in the 2 exhibits. She said, I'm going to allow a little bit of testimony on this. You can't have the exhibits. No reasoning offered, no opportunity to argue after she had ruled. Similar situation with respect to the testimony, the very important testimony of Mr. Joseph Pritzky. This is trooped through again in our opening brief and in a reply brief. Mr. Pritzky's testimony was, I would buy things based on ads. That's page, volume 1, page 320, never heard by the jury. I wanted to be like these people in the ads. That's page 343, volume 1. I wanted to have a sailboat. I wanted to have a pretty girlfriend like the people in the ads. Volume 1, page 420. The judge wouldn't even allow us to play Mr. Pritzky's testimony in which he identified a specific ad that he recalled that had the features that he said inspired him to want to buy Newport cigarettes. And instead, if you look at volume 2, page 1981, this is where the judge allowed the only statement by Mr. Pritzky about how he was influenced by ads. And this is what she allowed. She allowed him to say one sentence about having seen ads, and that was followed by defense counsel's question, where the question was, well, did the Newport ads have anything to do with your trying Newports? He says no. And there's a reason for that, because his testimony was that he tried the first Newport because it was handed to him, not because of the ad. But he didn't say, it's not like he said he wasn't influenced by the ads. This is the only testimony she allows about ads. She allows the...
Doesn't all of this testimony go to causation? Doesn't it all go to causation, not whether the defendants were negligent in marketing?
Well, okay, all of the memos...
his testimony that you're saying, that goes to causation, right? Okay, so if the jury didn't reach causation, how is that reversible error?
Well, it's reversible.
Assuming we don't agree with you on the main part of the claim.
Okay, so it wouldn't matter if they marketed children even though he heard these ads? I mean, I've never tried a case like that. Let me also point out that with respect to the claim that was called negligent distribution, which we wanted to call negligent marketing, the jury found that it was negligence in handing him free cigarettes, but didn't find causation. How are we prejudiced there, you might ask? Answer, because of all the things, again, the jury didn't hear. The jury didn't hear, and I want to be very, this is, to me, this captured it. Both sides were allowed to put in testimony about giving out free samples. The defendant was allowed to put in over an hour and 20 minutes of testimony by 2 corporate representatives. I objected to 26 things in their submission. The court overruled me I objected 29 times, the court overruled me 26 times. On my testimony, They objected 79 times, and the court sustained those objections 75 times. So we ended up putting in 19 minutes of testimony about sampling, and they ended up putting on 4 times that because of the way this went. This is, and I laid out those statistics in our opening brief. As to the substance of sampling, the substance was Mr. Pritzky's older brother and his younger brother both got samples. Jury never heard that. Mr. Pritzky's friends traded the samples amongst each other. Jury didn't hear that. Jury didn't hear the testimony of third-party witnesses. In one case, she got 50 to 60 samples in the same place that Mr. Pritzky did. Jury was not given this testimony. And I respectfully submit the De Jesus versus Yogel case, which talks about this question of whether something goes to causation. If it's liability evidence, can you consider it on the issue of causation? And in De Jesus, the SJC said yes, and why? And here's why it applies here. If the jury had heard the full scope of all the sampling activity going on in Mr. Pritzky's neighborhood, that could have easily affected their sense of whether that activity was causal of what happened to Mr. Pritzky. So you might say, kind of the converse of what you asked me about negligent marketing. But as to the testimony on sampling, we have to show why it matters on causation, and I've tried my best just now to say why that's so. Exclusion of television shows. I simply have no idea why the judge thought. The judge allowed Mr. Pritzky to testify that he watched the Flintstones and the Beverly Hillbillies and Dick Van Dyke Show. But the jury had no idea why it mattered, because they didn't get to hear the testimony that R.J. Reynolds and Laurel Art advertised on those shows. They didn't get to hear that.
I thought he testified that he did watch the Flintstones, but that he did not remember seeing the commercial.
Yes, Your Honor, it's true. And my point goes to the negligence of the defendant. If the defendant knows that this show is being seen by millions of children, and the court would not allow the testimony that 49% of the viewership of one of these shows were minors, she wouldn't allow that testimony. So whether R.J. Reynolds, and R.J. Reynolds, by the way, later stopped advertising on these shows, which was some evidence that there was a way for them to figure out how many minors were watching them, and they stopped advertising on them. So, Your Honor, my point about the commercials is they had reason to know that these shows were being watched by children. They had reason to know, this goes to the liability problem that we have to establish. They had reason to know that, and they had reason, and we wanted to be able to show them the actual cartoon of Fred and Barney Flintstone smoking Winston cigarettes. We weren't allowed to do that. So the jury was missing critical evidence on all of the negligent sampling claims, the negligent marketing claims, and in my last 7 seconds, I'm going to make the point about the conspiracy claims. On the conspiracy claims, the judge basically cut off our evidence. It's a 45-year conspiracy. The judge basically cut off our evidence after 10 years. And we outlined in our brief, page 50, where she started cutting off the evidence. She basically said, once she had heard that this had gone on for 10 years, to her, that was it.
All right, we're gonna have to leave it there. We have your brief on the issue. Thank you, Mr. Rayner.
Thank you, Your Honors.
Mr. Burnett.
May it please the court, good morning, perhaps good afternoon, Your Honors. My name is Jason Burnett. I'm here on behalf of the Appellees, Reynolds, and Stop and Shop. For just a little bit of context, this was a nearly month-long trial, 15 witnesses, 138 exhibits, and almost certainly hundreds of separate rulings on other exhibits, deposition designations, and objections to testimony. The court throughout this process, what is striking is how much thought and preparation the court gave to each of these rulings that have been challenged here. The court had clearly read everything, entertained extensive argument over several pages, gave the attorneys room to argue, and then gave reasons for her rulings, often on multiple alternative grounds. That's important, Your Honors, because what Justice Shin, you pointed out in the opening brief in this case, there is one argument going to one document, whereas the court actually gave numerous reasons for excluding documents. So, for example, she noted that the documents had no nexus to a marketing plan. Some of these documents were simply about forecasting. They noted the existence of a population group, maybe being 14 to 24, that in the future, as it matures, tomorrow's business, these documents said, would become younger adult smokers. They were about brands that were not alleged to be negligent marketing brands. There were only 3 brands that were alleged to be negligent marketing brand: Newport, Salem, and Cool. That's under the pretrial memorandum that was filed and the court's instructions that have not been appealed from. Several of these documents and some of the videos have to do with Winston cigarettes, for example. That was the brand Mr. Pritzky switched to when he was 18, no longer a minor. It wasn't the basis for negligent marketing. In fact, when the judge inadvertently said Winston in listing the 3 brands that were relevant to the negligent marketing claim, my brother corrected her, not Winston, Your Honor. Winston wasn't part of the negligent marketing claim, and that was part of the basis for the court's rulings on these internal documents, some of them.
Is it true that she excluded all of the internal documents?
I saw one document, a 1956 Lorillard annual report that talked about the importance of young adults who are in their formative years to the business of smoking. That's at page 1164 of volume 2. We did put in our supplemental record appendix the Roper polls that were commissioned by the companies that did show polling of 17-year-olds on various attitudes toward cigarette companies to show that the companies were, in fact, studying under 17-year-olds. There was testimony.
That's not an internal document, right?
Well, that was from our internal files. I think some of these documents that have been called internal company documents are not. They're from an advertising agency that was sent to Reynolds or Lorillard. This is no different from that, Your Honor.
I take it the reason the plaintiff tried to introduce these documents is to show the defendant's intent, right?
Yes, Your Honor.
So a survey wouldn't be relevant to that.
It could be relevant to showing that the defendants had an interest in studying under 18 buyers, which is exactly why they put in the testimony of Christy Leong, who was a 30B6 witness for Lorillard, who testified when she was shown, I think, some of the documents that my brother was referring to about Lorillard in the 1960s authorizing market studies of 16 to 29-year-olds. Those documents were excluded. They're the gray advertising memos, 1963, 2 from 1963, 1 from 1966. Those documents were admitted during her deposition. The court said, I'm not allowing the documents in, but I'm allowing the questions in. So the very sentence in the brief that the plaintiff says we wanted to put in through these documents was read in question and answer with Ms. Leong in the trial of this case at 1295.
Did the judge admit any evidence that the defendant smoked cigarettes because of advertisements he saw as a minor?
Yes, Your Honor. So my brother referred to the only point in the record being 1981. I would refer the court to 2022 and 2152. This was admitted testimony from Mr. Pritzky's deposition about the ads that he saw that caused him to smoke. He specifically said, so there is...
Could you repeat those page numbers?
Yes, of course. 1981 was the page my brother referred to. I'm referring the court to 2022.
This is of record volume 2?
Yes, Your Honor. And 2152.
Okay, thank you.
And there may be a span of pages there. I've just caught the first ones, but
Did defense counsel argue in closing that the jury has heard no evidence that he smoked cigarettes based on advertising he saw as a minor?
Defense counsel argued that because of advertising, Your Honor, that he made a smoking decision because of advertising. There was testimony from Mr. Pritzky that he recalled these Newport ads, these Salem ads. They made him feel glad. Importantly, they validated his choice to smoke Newports. That's one of the comments that the plaintiff claims was excluded in a ruling of Mr. Pritzky's testimony. I think it was the first bullet point in their brief. That was cumulative of another portion that the court allowed in, specifically from Mr. Pritzky saying, the Newport ads that I saw validated my smoking, my choice of their brand. He talked about ads showing beautiful places and beautiful girls, and that they were glamorous. So there was this testimony that was admitted from Mr. Pritzky on his response to advertising influencing his smoking behavior. But there was no specific testimony, Mr. Justice Meade, excuse me, I think you referred to, there was an acknowledgement by Mr. Pritzky that he couldn't recall specific product ads in the Flintstones, for example. And so there was missing a specificity in the testimony that provided the basis for the closing argument from our counsel.
Did the judge also exclude it based on the cartoon ran in prime time?
She did.
Wouldn't that, I mean, obviously children often watch primetime television. I'm a product of that myself, and yet I'm still a judge. Wouldn't that just go to weight and not admissibility?
I don't think it goes to weight when you sort of layer on everything here, Your Honor. So the Flintstones commercial dealt with Winston, not a negligent marketing brand. The Winston commercial played at prime time. It was a cartoon, but an adult comedy. My brother said that it was switched at one point, which shows that Reynolds could monitor the audience group for the Flintstones. Well, it switched because at the time that these ads were played, it was a primetime show. It was then switched to a Saturday morning cartoon, and Reynolds pulled its sponsorship. So at this time, it's intended for adults, and it is running at a time when the adults are watching. There was testimony from Dr. Proctor, plaintiff's expert, that even among primetime shows, children's audience was in the double-digit percentage of the audience for those shows. So there was evidence before this jury that television shows and the defendants' marketing of their products on television shows supported the negligent marketing claim. But because it didn't involve the right brand, because it was not targeted to minors, and because it was in fact cumulative of the plethora of videos, that's what the court said. You've got a plethora of videos. There were Salem commercials, Newport commercials, Winston commercials, the Lucky Strike hit parade where Ted Williams was shown, Frank Sinatra, who was described in the testimony accompanying that video as part of the teenage crowd, and other videos showing movie clips where product placement of smoking was used. So there were abundant video clips showed to the jury. This clip was excluded. The court could consider the probative value, the minimal probative value, and courts have to do that kind of weight analysis when making any kind of evidentiary ruling. It's considering the weight, but it's considering whether it's admissible given the minimal probative value, the likelihood for prejudice and confusion of a cartoon show showing a cigarette commercial when modern, lay witnesses will not understand the different circumstances at that time of it being an adult comedy, and the other testimony that was admitted in the case. It was well within the court's
there was evidence that that was advertised as an adult comedy, so why isn't that something the jury could consider as a question of the weight to give the evidence? I mean, it seems like the judge, she was very careful. I know this was a massive trial, but she did seem to make a few calls that were on the line. It guised as a determination of relevance when it seems like easily an argument could be made that it goes to weight and not relevance.
Well, Your Honor, for the Flintstones video in particular, once the jury sees that video clip of a cartoon with a cigarette ad, it can be prejudicial. I mean, to put it mildly. And so I think there is a role for the court to exclude evidence and not wait.
Prejudicial because it's bad for your case, or prejudicial because it's unfairly prejudicial?
It's unfairly prejudicial.
Why is it unfairly prejudicial?
Because it's not targeted to minors.
Well, I mean, if they knew that children might be watching it, even though it's a primetime show, it was preceded by another cartoon, I mean, it seems like it would be a jury question to me.
Or if they had a survey that said 49% that watched it were minors.
Yes, Your Honor, that was the evidence supporting the Dick Van Dyke Show. The Dick Van Dyke Show was, again, about Kent, not a negligent marketing brand. But the point is, Reynolds, at the time, even today, has the right to lawfully advertise. At that time, had the right to advertise on television. These were primetime shows. There was no evidence submitted that there was advertising on these shows for the purpose of attracting youth underage smokers. There was the incidental overlap that some primetime shows would also have a youth audience, but that could be used as any advertisement. Under the SJC's decision in Evans, there's no breach of a duty to market to adults. Marketing to adults was what was being done here on television shows that ran in prime time. And again, I just want to say there is a harmless, this evidence was harmless in the exclusion of it because there was testimony from Dr. Proctor about television ads that ran, about children's share of the audience of television shows, and there was testimony from Mr. Pritzky about television shows that he watched. So there was evidence sufficient to support the negligent marketing claim here, Your Honor.
Can I ask you about another document, the 1964 memo referring to the fun cigarette and the marketing, what did it say, marketed successfully to youthful and immature groups. And one of the reasons the judge excluded that was, I think, relevance, because youthful and immature without more doesn't mean underage. Why isn't that also just a question of, a fact for the jury?
Well, without more, it doesn't mean that they're under 18, Your Honor.
Right, I understand that.
And then, in addition, I think the main ground, actually, for this ruling was that this ad, this 1964 Lorillard ad, was cumulative of the testimony. So there'd already been testimony extensively from Dr. Proctor on Lorillard, through Marketing Newport, of young, fun, and healthy ads.
But the document, if it's an internal document, and it was offered to prove intent, which Proctor's testimony couldn't show, so it doesn't seem to me to be cumulative.
Well, it is cumulative of, if there is evidence that the advertising chosen and directed by the defendant had themes of young, fun, and healthy, that is evidence from which a jury could infer intent. There was actually a pretrial stipulation in this case that prevented Dr. Proctor and any expert from giving testimony on the meaning and intent of company documents. So this was going to be a matter for argument. So the argument could be made from the advertising. The youthful and immature references in this Lorillard document, without more, only say that they're looking at groups of buyers who are younger than other segments of buyers. It doesn't say under 18. There would have to be some sort of speculation by the jury to read these words to say, oh, that means under 18. That's what's happening here. The plaintiff's expert couldn't supply that intent because there was a stipulation that the expert would not give that kind of testimony. So how's the jury going to find the evidence that this reference to youthful and immature means under 18 except to speculate, oh, that's what they really mean. They really mean it has to do with underage buyers. And if there were other evidence that showed this is what that term means in this document, then that could support the jury finding, but otherwise it's speculation, Your Honor. I think this brings me to the sampling issue. I just want to make sure it's pellucidly clear that the jury did find there was negligent distribution sampling to Pritzky. That was the verdict form, but that there was no causation. And so this
And your opponent says that it's still relevant under De Jesus. Do you have a response to that?
It's not relevant. Before I get to that point, Your Honor, I would like to, well, let me just address that directly. This testimony is by people who did not know Mr. Pritzky. These are 3 non-parties. They have no information whatsoever about Mr. Pritzky, so they can't address what the basis for the cause or non-cause of the negligent sampling on Mr. Pritzky. And so that's why it's harmless in this case. And so,
Okay.
And there has to be some showing that it would plausibly affect the outcome of the case, Your Honor. But the jury agreed with plaintiff that there was sampling going on. These other witnesses that they claim were excluded only dealt with the policy, whether there was a policy to sample. The jury agreed with them on that question. What's left is causation. Did this cause the cancer that later developed? The jury heard evidence in this case about declining risk because, in fact, Mr. Pritzky quit smoking when he was 35 in 1987. And so the jury could have found that there was declining risk from the time he quit smoking, the negligently marketed and sampled brands started smoking Winston's, and so the negligent sampling and distribution had no causal effect on the cancer that later developed, Your Honor. But the point is that these other witnesses do not relate to the causal element of that claim. Thank you, Your Honor.
Thank you. Thank you both. We'll take it under advisement. With that, it'll bring to close our session. I'd like to thank our court officers, our court staff, our clerk's office, my colleagues, our law clerks, the excellent timekeeper, and with that, we'll stand in recess.
All rise.